All right. Good morning, folks. My name is Julian Morse. I'm the MLA for Frame Lake and chair of this committee. This meeting is being live streamed on the Assembly's social media channels. So as a reminder, please direct all comments and questions through the chair, and please wait to be recognized and for your mic to be turned on before starting speaking. We'll now ask members to introduce themselves. We're going to start with Mr. Rogers on my right.
Thank you, and good morning. My name is Danny Rogers. I'm the MLA for Inuvik-Boot Lake.
Good morning. I'm Kate Reed. I'm the MLA for Great Slave. Thank you for joining us today.
Thank you. And I think we have at least one member online, Mr. Hawkins.
Thank you, Mr. Chairman. My name is Robert Hawkins, MLA for Yellowknife Center, and as always, I'm happy to be here, and I appreciate the opportunity to zoom in. Thanks.
Excellent. Thank you so much. Okay, so this morning, committee is hearing from the Information and Privacy Commissioner, Andrew Fox, as part of its review of the 2024-25 annual reports of the Legislative Assembly statutory officers. He's accompanied by Assistant Commissioner Megan Holzapfel. Thank you very much for joining us. I'm going to turn the floor over to you and for opening remarks in your presentation, and then as you're well aware of, we then open the floor to questions from MLAs. So over to you, Mr. Fox.
Thank you, Mr. Chairman. Thank you and good morning to the other members. And we're going to do a little bit different presentation than we typically have, which is to say, I'm not going to deliver it today. Assistant Commissioner Megan Holzapfel is going to deliver it. I don't really have any preliminary remarks. I'm going to just turn it over to Ms. Holzapfel and we can go from there.
Hello, everybody. I'm not going to read our report to you because I know everybody's really keen to ask the commissioner questions. But I do want to touch on the main points so that you're not needing to ask the more basic questions about why we're here. So first off, we do not work for the government. The Legislative Assembly appointed the commissioner to be a watchdog, an independent office to provide accountability about information and privacy in the government. Now, sometimes we do that by reviewing the government's responses to ATIP requests, line by line, word by word. Sometimes we're investigating privacy breaches in the health system or in the government. We report our findings publicly, like in this meeting right now. And we also publish our reports on a public database. So we're here to tell you that the government is falling short more often than it should be. Sometimes it's holding back information that it is legally required to disclose. And very often, it's not responding within the timeframes this assembly set. And there are things that your committee can do about this problem. This assembly passed laws about what the government needs to do when people ask for information. But then it didn't make sure that there were enough trained staff to do the work. Not at the Access and Privacy Office. They do the bulk of the work over at Justice. Not within the health system, and not in the government offices in your communities. So this committee and you as MLAs can make sure the government takes this seriously. They need trained staff to do the work, to help them meet the legal obligations that this assembly set for them. Democracy requires that people can find out what the government is doing. This assembly passed a law, and it says that when people ask for information, the government needs to respond openly, accurately, completely, and without delay. But the practical reality is that that is very, very difficult without good record keeping, without trained staff, and without strong leadership that's committed to transparency. This Assembly's laws only make a practical difference when they're implemented with trained staff. So I'm going to describe the access and privacy laws really quickly. The Commissioner has authority under both of them, and that power comes from this Assembly. Now, ATIP applies to most entities that were established by NWT laws. So that's departments, health authorities, school boards. So this slide shows some of the bigger players. They're called public bodies in the law. Most of the departments have help from the Access and Privacy Office at Justice, but everybody else needs to assign their own staff to process the requests. And in every case, it is the public body itself searching for records when a request comes in. And in every case, the head of the public body is the one that's responsible for providing a response within the deadline that this assembly set. And I want to stress again, we are not the Access and Privacy Office. The APO is part of the government. They help departments process requests. Now, the commissioner's in a quasi-judicial role, overseeing the system, making legal orders, reporting back to this assembly about whether the government is doing what the law requires. And I know it's a bit unusual for your committee to have somebody come here and say, our office is properly funded, but this other government office needs more resources. But that is what we're here to tell you. The government just gave the APO 2 more positions. New staff should help long-term, but it is too soon to know if this is enough to get the work done on time. It needs to be supported in the departments. Now, an ATIP request is a formal request for records. This is the form that the government uses. Most government information is accessed informally. So that's websites, it's publications, just normal conversations where an employee explains how things work. And all of that, much simpler than this more formal process. Now, responding to an ATIP request involves gathering the records, sorting through them, find out which ones meet the description in the records request, and then going through each one line by line to make sure that the disclosure is what the law requires. That is time-consuming, and it means you need staff who know what they're doing. And the law sets time restrictions for responding. So the reality is, if this is not somebody's main job, other staff need to be reassigned to do the work. And it is even more difficult when the records are not organized. The ATIP Act is over 30 years old. That's before email, it's before text messages, it's before all of our modern electronic systems. In 1994, a record was created on a typewriter, and then it was filed in hard copy. There have been updates to the Act since then, but this is a very, very different world right now. So public bodies need trained staff to help them with record management. They need to respond to requests for information. They need to document their decisions for the future. Now, the Health Information Act is newer. The first 10-year review is underway right now. We have had some high-profile cases lately. Employees of health authorities deliberately seeking patient information that they do not need for their jobs. And that is serious, but it's rare. Almost all health privacy breaches happen because the staff are distracted and overworked, and they're sending patient information to the wrong place by accident. Now, the underlying issues are serious. They have broader implications, not just privacy, because patient information that's sent to the wrong place is not in the right place. It's not available to caregivers who need it. They're working from incomplete information. So that is a problem for people in every community. And most of our recommendations relate to the Health Information Act. So stay with me, I am going to come right back to that. This chart is in our report. It shows the review reports that we put out every year. Red is ATIP. So those are mostly reviews of redactions. That's the blackout text we all know from the news and from movies. The person who requested the records has asked us to double check the public body's work to make sure that they received everything that they're legally entitled to. Now, this is a very small proportion of the overall number of ATIP requests. Most people do not ask us for reviews. Blue is extension of time. Public body needs more time to respond to an ATIP request, and the commissioner can authorize an extension past the 20 business days. And we're going to talk more about that in a minute. And yellow is the Health Information Act. And again, small percentage of the total. They are almost all related to privacy breaches. Last year, we put out 15 review reports, and the health system sent us 173 reports of breaches. So most of those are minor, and we resolve them pretty quickly. In almost all cases, the health authority has already addressed the issue that led to the breach. But there are some continuing big picture issues that we think need to be dealt with. So our first recommendation is for a change to the ATIP Act. So I mentioned every request involves reviewing the records line by line, word by word. And one of the things that staff are checking for is other people's personal information. It is very common for government records to have personal information in them. Just think about income support programs, think about procurement, even a very simple consultation. People consent to the use of their personal information. It's documented in a record. And then if somebody makes an ATIP request for that record, there's a process for giving people notice, asking them if they consent. That process takes more time than the Act allows public bodies to take on their own. They need to ask us for more time, and normally there's no basis for denying a request. So again, that is the blue bar on this chart. It is not large, but that's time that staff could be using to process requests. It takes up time in our office too. So this change would allow the public body to follow the law, complete the third-party consultation without needing to stop and ask us for the time we know they need to do the work. They could just keep working on the request. And if they still need more time after that, then they could come back and make a request for an extension. So the second recommendation is to provide oversight for recommendations in health privacy breaches. All of our recommendations from here on out are about health privacy. When we do a report on a health privacy breach, we often include recommendations to prevent similar breaches. So if the health information custodian accepts the recommendation, it has to comply within 45 days. But there's no reporting process. And we think it would be helpful to have a requirement to check back in with our office about how it's going. Third is fax machines. The health system is still faxing personal health information, and it is still going to the wrong place sometimes. So an employee is distracted, hits the wrong button, has no idea that confidential medical information has just gone to a fax machine in the wrong community, sometimes not even within the health system. And then the person who picks up the fax documents is often not the person who needs the information. And this is all happening within a health system that has secure file transfer and the EMR almost everywhere. Faxing is almost never necessary. It should be kept to an absolute minimum, used only when there are no other options. Fourth is privacy training, and this is good practice for all public servants. The Minister of Health and Social Services has made annual privacy training mandatory for everybody in the department and the authorities. Keeps privacy top of mind, and it's a chance to talk about breaches. It is not a guarantee, but it is a really helpful reminder. It supports a workplace culture that protects privacy. It's mandatory, and our office strongly supports this annual training. And finally, we've got two on one slide. Privacy impact assessments are really useful planning tools. When a new project is being developed, privacy staff analyze it for risks, and then they design privacy protection into the system, and the assessments come to the commissioner. The ATIP Act said that needs to happen while the project is being developed, and the commissioner provides comments. But the Health Information Act only requires the assessments to be provided to our office. The commissioner may provide comments, and there is no time limit. But if the purpose is to prevent breaches, the assessments need to happen during the planning stage. In one extreme case, our office got a PIA from the COVID Secretariat after it had shut down the project it was assessing. So that was a system that the Secretariat had used to email people with self-isolation plans. You might recall it was emailing personal health information to the wrong people. Now, the privacy staff who wrote that PIA had identified the exact problem that had plagued the system. So a bit of a theme here. The Department of Health and Social Services has in-house privacy staff to help it prevent, respond to privacy breaches. So their expertise needs to be integrated into projects at the planning stage, not after implementation. So those are the recommendations, and I know everybody is really keen to hear from the commissioner, so I'm going to hand this back to him for any questions about our report or our office's work.
Excellent. Thank you so much for the presentation. I have Mr. Hawkins first online with questions.
Groovy, Mr. Chairman. Thank you very much. I appreciate the presentation. First of all, I want to stress, I appreciate the style of the presentation. It's very spirited. It's in a nice way. It's very direct in a nice way. And it feels like it's really putting the finger on some of the challenges. I don't want to say failings, but and responsibilities, but I'm kind of saying the failings and responsibilities here. So I just have two questions right at this particular second, and I may have more down the line, but my two questions, I'll give it to you both at the same time, because the first one's purely, I'd like to think is fairly easy, and the second one is similar. I thought about what it was just mentioned when preparing for the meeting. So the first real question is it time to demand that faxing, that is, goes the way of the dodo bird? I mean, given the consideration of how many times misfaxed information is sent, it's caused these interesting quagmires. And the fact, and in particular, when I note that the courts And no offense to the courts, but they're almost like the slowest organization out there for change. Have, accept emails and e-signatures and online, like they've moved into at least the late 20th century. I don't know if they're at the next one yet, but needless to say, they have advanced so far that, in other words, can we get rid of fax machines and can we start demanding end the fax era? And the second area is just ever so briefly, is the act, in your opinion, written in a fair and realistic way? And sometimes we have expectations. And the tangent I'll say is, I bring my car into the garage and they say it needs work, and I say, can you have it back in 20 minutes? And they said, come on, it takes an hour just to order the parts. So in other words, unrealistic expectations. Is the act written in a fair way with the spirit of expectations that the obligations to be met are too high, the expectations are met are too unrealistic in the way it's written? And that has nothing to do with access to people's information. It's just the obligations that have framed the expectations of the department to rise to the request. So in other words, they've been set up to fail. So anyway, those are my two areas of concern when I was prepping for the meeting. Thank you.
Okay, thank you. Over to the Privacy Commissioner.
Thank you, Mr. Chairman. Thank you for your questions, Mr. Hawkins. Starting with the first one, you're asking about whether it's time to, I guess, demand or direct that the health system stop using fax machines. So not too long ago, NTHA, which is the largest of the health authorities, developed a fax policy which instructs to not use fax unless it's the only option and the matter is urgent. So that goes a long way to addressing the problem. It doesn't go all the way because fax still continues to be used. The fax policy includes a provision saying that you should always use secure fax, which is a method by which when you send the fax, the receiver can only get it if they use a certain code to retrieve the fax. So you never have the problem of it going to the wrong place and then printing out and anyone can see it. So that can be a useful thing. Unfortunately, it doesn't get used all the time, and that's, I think, in part because you have older infrastructure. Not all fax machines have that feature. Not all fax machines that have that feature are turned on to use it. And of course, using that security feature adds a little bit of time to the transaction of picking up your fax. And in a busy workplace, this is often something that people are quick to sacrifice in order to get it done a little bit faster. And as I pointed out before this committee, those sorts of decisions made on an individual basis are understandable, but they become problematic at an institutional level because when these things go wrong, then there is a sort of downstream effect because now there's a privacy breach report and there has to be investigation, there has to be responses, our office gets involved, et cetera. So it creates sometimes a significant downstream set of activities that could be avoided quite simply by using that secure fax or by sending the file by secure file transfer, or as alluded to, using the electronic medical record to deal with the issue itself, because there are communications modes within the EMR, and in general, it is a better thing to put a document somewhere secure and then invite someone who's authorized to look at it to go look at the document, rather than distribute copies of that document through some other communication process, because now you add to the proliferation of these documents. And sometimes they go to the wrong place. So to answer your question about is it time to demand the fax be removed, I don't know that that would be rather getting into the weeds, I think, in terms of how NTHA or the other health information custodians sort of manage themselves and their infrastructure. And as I understand it, I mean, the policy as is written is that fax should really only be used in emergency kind of cases. Now, what those look like, Not really, I don't really want to go into that, but one can imagine that there could be, but I don't think that this would be the time. And we're not, we certainly haven't recommended that they get rid of the use of fax machines in favor of more secure methods. I don't know that now is the time to say that there shall not be any fax machine used. So, does that answer your first question, Mr. Hawkins?
Thank you, Mr. Hawkins.
Yeah, I'm fine with that. I mean, I would have preferred to hear, we're recommending to get rid of fax machines. We think that you should move away from them, but I also appreciate and respect your comment of their observation. They're trying to do secure. I just think that the challenge ends up being is then someone's busy, they're lazy, they forget to do it that way, distracted, whatever the case may be. There's hundreds of reasons why they don't follow through on that. And some of them are just realistically, oops, and that's how it happens. Like they missed it or forgot it. Not nefarious in any form, just by happenstance. So I was just, I'll say I'm fine with that answer. I mean, I think that was a fair response, given your role and your audience of who you do send the report to. So not a problem. With respect to the other question, I guess. Thank you.
Okay, thanks. You still have the second question in your mind, Mr. Fox?
Yes.
Okay.
Yes,
Excellent.
thank you, Mr. Chairman. So the second question, if I can sort of sum it up, is the act written with reasonable expectations vis-a-vis timelines and obligations? And the act being the Health Information Act that we're talking about. And I think that's a tough one to answer. It has a set of obligations. Most of the timelines in the Act are not couched in specific periods. There's one or two that are. Most of them are framed as, in language using, as soon as reasonably possible. Now, we often receive things like reports of privacy breaches that are supposed to be reported to our office as soon as reasonably possible. And it's not unusual for us to receive those reports 3 months, 6 months, 9 months, a year, or longer after the health information custodian has had notice that this breach occurred. There are reasons for that. Well, I think operationally there are times when there's not enough staff to pay attention. There are instances where files get lost in the shuffle, if you will, when there is, say, a change in staff or a change in management and things get misplaced. I mean, those are problematic, but it is an observation that we often get reports of breaches in 3 months, 6 months, a year after the custodian knows that it happened. And, we typically will comment, sometimes only in a letter, but sometimes in a review report, that is not what as soon as reasonably possible should cash out as. And one of the themes in the presentation or one of the statements is about dedicating sufficient resources to the task. And I've met with the CEO of NTHC a few times over the years, and one thing I was surprised to hear was that the privacy unit that has been set up within NTHC over the last, I guess, four years, it wasn't in place when I first got there, but they've created a unit with some investigators and a manager, et cetera, to deal with privacy breaches, across that organization, and which is something I have a lot of respect for and a lot of time for, because it really is a skill that is not held by everybody. Investigating what happened in a breach requires a certain sort of mindset and a familiarity with what the Act views as a privacy breach. So they've created this institution, if you will, this unit to take part in that and to guide the investigation, to do the things like giving notice to the person who's been affected, giving notice to our office, identifying what the problem was, trying to identify what mitigation measures need to be put in place, what kind of long-term measures might need to be adopted to try and avoid those things. I mean, those are the questions that really arise when a privacy breach happens. Strangely, that unit has been put together without dedicated funding in a budget, but by borrowing, stealing money from other parts of the HSSA budget. And that's a problem, it seems to me. And it really comes back to the fact that, you know, the healthcare system, I think, is sort of notoriously always strapped for funds, and trying to get dedicated funding for something which is administrative and one remove from direct patient care is probably a tough one when there are so many other demands on those funds. However, privacy with regard to personal health information is a key part of delivering health services, and it is certainly a legal obligation that the Act points to. And the reason why it is there is because of the sensitivity of all of that information. So when the Act says if someone's personal health information has been used or disclosed or destroyed or lost without authorization, you need to tell the person whose information it is as soon as possible, as soon as reasonably possible, because it's their information and they may need or want to take some steps to find out more. And at the same time, notifying our office, which is, you know, performing that sort of watchdog service, we will start our inquiries like, what happened here? Now, sometimes, often, it's not a big deal. There has been a privacy breach, but the breach was discovered reasonably early. It was mitigated quickly. If it was sent to the wrong place, you know, very quickly, it's you know, that copy has been destroyed, and the document's been sent to the right place. I mean, responses do happen, generally speaking, in a reasonable way after the error has been discovered. But doing that all in a timely fashion sometimes, well, often is a challenge. And I would attribute that to the simple fact that there aren't enough people doing that work. And I think there are some operational difficulties in terms of what authority that unit has and how it works within a much larger organization. But whether the timelines, getting back to the question, whether the timelines and the obligations are in the Act are reasonable, it really depends on how much resources or how many resources are going to be dedicated to those. If you have one person in an office and you've got, you know, several hundred complaints a year, there's no hope of getting it done on a timely basis. That office has recently, like within the last 6 months, increased its staff. So we are cautiously optimistic that things will continue to improve.
Okay, thank you very much. Mr. Hawkins, you effectively asked two questions there, but did you have a quick follow-up maybe? I do want to give other members time too.
No, I don't want to
Okay.
delay or monopolize. It was fine. Both answers were fine. Thank you very much to the commissioner and certainly the staff. Thank you.
Okay, excellent, thank you. Ms. Reid, I have you up next.
Thank you, Mr. Chair. And thank you for your presentation. I also appreciate the frank candor and enthusiasm behind the presentation. I do have two questions as well. I'm going to start off with one that as you may or may not know, I have quite a lot of experience in my prior roles processing ATIP requests, and something that I always came across and I'd like to ask you about today is the annual report notes that your office receives several requests to review responses to requests for all records. It's noted generally this greatly increases the volume of records, the time required, and the complexity that's involved in a response. And then the response only ends up in providing records that are little to no interest to the applicant. So could you share what options you have in your role as commissioner to address this issue, and whether any solutions would be best placed in policy, legislation, or through government practice? Thank you, Mr. Chair.
Okay, thank you. Mr. Fox.
Thank you, Member Reid, for that question. I would go first to Section 7 of the Act, which creates an obligation on the part of a public body to assist applicants. And often applicants are not particularly well versed in the records management practices of the public body that they're interested in. They don't know where documents are. They don't know what they're going to be called. They might be somewhat fishing around for something that they may or may not, or that may or may not exist. And so one response to that is to go wide with the ask and to say, well, I want everything you've got on X. And sometimes the public body will have a lot, and that creates a real problem, because if you give a very broad ask and your responsive record collection looks like 5,000 or 10,000 documents, that obviously creates a huge problem. Now, the Access Privacy Office is the one that has that problem first, because they're the ones that have to go through each page line by line and determine what, if any, exemptions to disclosure might apply. And then sometimes that requires some further consideration and consultation with third parties or with businesses, sometimes with other departments. And ultimately, a recommendation package goes up to the head of the public body, and then they have to take a look at this. So that can be really onerous if you're talking about big collections. So that's, I guess, that's the substance of your question. Like, how do you avoid that? Generally speaking, I don't think that applicants are looking for big collections. They're looking for something. Now, the duty to assist is, I think, the place to look, because a public body, and generally this is the Access Privacy Office, because they are the front end, they're the window for the public to submit their requests. And it is, my experience that they often will speak to the applicants and try to narrow down the ask, try and figure out exactly what it is that they're after, and in as much as they can, try and narrow the ask. Now, they're not in a position to say, or to be too prescriptive about what that should look like, because they don't know what the applicant's actually looking for. And if the applicant may themselves not be too sure, which of course creates a problem, because if you don't really know what you're looking for, then it'll be difficult to find it. So trying to put clarity on the ask, that's one of the first things the public body needs to do, and it does that through the work of the Access Privacy Office when they're dealing with those applicants. Sometimes applicants don't want to hear that. They're looking for some smoking gun, and they don't want to tip their hand about what that smoking gun is. So they just want to say, I want everything. I'll do the sorting. And there's not much that you can do about that, other than there is a fee structure that applies, and when the access request generates documents that go over, I think it's $250 or $295. Anyway, there's a threshold, and if the cost goes beyond that, then the person will be required to pay some fees, unless it's personal information, in which case there are no fees applied. Now, one underlying concern there is the amount of administrative work it takes to respond to these large requests. And that's a real practical concern. One of the other underlying concerns is the need to ensure that the public has access to information the government holds and is using on behalf of the public. And, that is a keystone to running responsible, open, democratic government. So in any particular instance, it just seems, I think it can be experienced by the people involved as just more work, to which I would say, not too naively, that it's pretty noble work. And we should defend that right of individuals to make these broad requests. At the same time, though, if someone is asking for something, we really do have, there is a legal obligation to help that person figure out what exactly it is that they're looking for, so that they can, so that first the public body has a better shot at finding it. And that would then lead to, less work for government, but also it will likely lead to a better result for the applicant. So I'm not sure that I actually answered that question satisfactorily, because if the question was, how do we stop the big asks, I don't think you can. I'm not sure that you should.
Okay, thank you. Ms. Reed, follow-up.
Thank you, Mr. Chair. And, I respect the philosophical element to my question. I was asking it a bit more in a pragmatic, solutions-based way, but I do recognize that every resident has the right to the information that they seek. I was just curious, I suppose, if you thought that perhaps the adequacy of the APO, for example, in terms of their research interview practices, if you have confidence in that they are following the act as best they can, fantastic. I won't press further. But I do have a different question. So I know, if you want to go ahead.
Mr. Chairman, if I could just respond to that
Sure.
comment.
Well, sure.
Thank you. Just to respond to the issue about, resources within the Access Privacy Office, which is something that we mentioned in the presentation briefly. That office has been recently given extra staff, 2 new positions, which is essentially a 40% increase, because they were at 5, now they're at 7. It's too early to say if that's enough. Certainly, early this year, like in January, the statistic was something effective. They were late in responding 60% of the time, which had been an increase from 2 years before, which was late 50% of the time. Now, I've certainly made that issue about APO resources sort of a frontispiece a few times, both with this group and with the deputy minister's meeting I've gone to a couple of times. And that message seems to have come through. Whether it's enough yet, don't know.
If I could just add, it's
Please.
not, the demand is not.
Oh, wait, you gotta wait for your mic. Go ahead, Ms. Holzapfel, sorry.
The demand is not just on the APO. So the APO is helping to process the requests, but it is actually the department that does the initial searches and sorts through things. So if the request is for something very broad, like I want everything about caribou, or every document that references some public figure, the number of records could be huge. And so there's work happening both at the APO and in the departments.
Okay, thank you. Ms. Reed, follow-up.
Thank you, Mr. Chair. And as Ms. Holzapfel knows, I'm quite aware. My second question is more directed at your report itself. There are 6 recommendations in total, I believe, one of which is pointing directly at the ATIP Act, and the rest are around the Health Information Act. I would note that all of your recommendations are restated recommendations from last year. And I'm wondering if, I'm not telling you I'm not asking or telling you what you think committee should be doing better, but in a way, I suppose I am, because our reports don't seem to be landing in terms of, we agree with your recommendations, we bring them to government, and it doesn't seem like it's being as successful as perhaps committee and your office would hoped, and I'd love to hear your thoughts on that. Thank you, Mr. Chair.
Thank you. I certainly have some thoughts, but I'll pass it over to the commissioner. It's not my job to be answering the questions here.
Thank you for that question. I guess the requirements for well, I'm not sure if we can. Sorry, I'm going to ask you to restate your question, because I'm trying to put some contours around it.
Okay, Ms. Reed?
Yeah, not a problem. And I recognize that it might not have contours, and it's more of more of a conversation than a question. As you know, the recommendation in this year's report are all restated from the previous year's report. Committee has done its work putting them forward as things that we would like the government to act upon, and clearly they have not been acted upon to the satisfaction of your office, because they're your recommendations once more. So I think I'm asking, what more can committee be doing? Thank you, Mr. Chair.
Thank you. Mr. Fox, some political advice for committee?
That's probably a little bit beyond my purview, but certainly, yeah, the observation that most of these recommendations have been recommended before is true, which is not to say that recommendations made prior that don't appear here have all been satisfactorily followed. There is a certain picking and choosing about what to recommend for in a particular report. The recommendations for that are directed to Health Information Act issues, that in part was a focus because there is a Health Information Act review going on this year. The response to recommendations in the past it takes time, I think, for government bureaucracies to move and to change practices. And it would be naive to sort of expect that recommendations made here today in 6 months will have some perfect solution. And even the process of making the recommendation, filing it with the annual report, presenting to this committee months later, and then this committee will months later issue a report to the government, and then months later the government will respond to that report. That's quite a bit of time. And in the meantime, things continue. Sometimes things improve, sometimes they don't. And even if things are improving, they might not yet be reaching the ideal situation. So I don't think it would be fair to look at the recommendations and say, well, that's been there before, so there's been no improvement. It would be fair to say that if the recommendation is here, in our assessment, there's still work to be done.
Thank you. The teensiest of follow-ups, Ms. Reed.
Quite right, Mr. Chair. Thank you for your indulgence. I would also note that the Department of Justice has a review of the ATIP open to the public right now, and I certainly hope your office is participating in that process, and I certainly hope the public who is listening participates in that process. Thank you, Mr. Chair. More of a comment, really.
Indeed, thank you. Mr. Rogers, I'm going to turn it over to you for questions.
Thank you, and thank you for the presentation. Certainly enjoyed it. Thank you for the recommendations again, and I think committee agrees on those recommendations. It sounds to me, and I know you've alluded to some of this, I think, when you answered both Mr. Hawkins' questions and MLA Reed's questions around HR, and it seems like it's a human resource issue at its core. It seems like it's that the issue here is we don't have enough bodies. And I guess if you could maybe expand a little more, I mean, is it sheer numbers, or how much of it is sheer numbers, either at the APO or in the departments that need more staff? And then maybe speak a little on the qualifications to those positions. Is the training not, is there numbers there, but the training is not getting done? Or is there, and what kind, I mean, and I don't know what qualifications you need to do this work. Obviously, it's very, very detailed, very important work that needs to be done accurately. So can you maybe speak to that just a little more around the numbers?
Thank you.
Thank
Mr.
you,
Fox?
Mr. Chair.
Thank you, Mr. Chairman. Thank you, Mr. Rogers, for that, I guess, observation and question. I would say that working in access privacy, access to information particularly, a sphere requires quite a bit of technical knowledge. You can't just grab someone off the street who might have some clerical background or what have you, or even a legal background, and just say, okay, here's some access to information requests. I want you to sort through them and get this out the door. It's a surprisingly complicated act to apply in regard to actual records. There is a suite of exemptions in Division B of Part 1 of the Act, which cover a whole gamut of things, some of which are required to be exempted, some of which there's discretion to exempt. Some of them, for instance, involving third-party personal information, have a long laundry list of kinds of information where a presumption might apply, a long laundry list of situations where a presumption does not apply. There is a consultation process involved. And then there are a host of other exemptions, which we won't get into, but all of which is to point out that it's actually kind of complicated and technical work. And there are some degree or certificate programs out there. I don't know that that's necessary, and I don't know that either the APO or the privacy unit in NTHC require that of people in order to be eligible to be in those positions. But it's definitely something where training is required, and some, you can develop this on the job, I suppose, but there needs to be a certain sort of legal mindset to understand the language of the Act and how it's applied. And my expectation is it would take several months for somebody to get, reasonably, quote, up to speed. And even then, there can be difficult parts where you might need to get legal advice from the Department of Justice to figure out a particular issue. So what the specific qualifications might be for those positions in the Access Privacy Office or the Privacy Unit at NTHC, I mean, that's kind of up to them to decide what they need to have, taking into account that they almost certainly have their own training programs. And I know the Access Privacy Office has its own manual, which is quite extensive on how to apply the Act. But you can't really expect to just sit down and get to work on it if you haven't had the benefit of that kind of experience and training.
Okay, thank you. Mr. Rogers, do you have a follow-up?
Thank you, Mr. Chair. And yeah, and I'm, in your report on the challenges to responding to requests, you did reference one extreme case where a public body waited 2 weeks before assigning a staff to request it. So I mean, I'm not going to say it's an afterthought for some departments, but I guess just quickly, I mean, if there was a significant increase in HR, or it would throw bodies at this, which also means obviously throw funding at this, because with those positions comes funding for them. Do you think a lot of the other issues that you see would then kind of be alleviated with that? So at your core, do you think this is more of an HR issue than it is you know what I mean? Obviously you want trained staff, but I mean, whether you're faxing something to the wrong department because you're super busy or because you've got too much on your plate to do, or whether it's on the corner of someone's desk and it's not their main job to do, so therefore it kind of gets pushed aside because all these other important things that they're having their neck breathed down to get done. So is this something that you think needs more focus from an HR perspective at the APO, at the departments, and would that then kind of alleviate a lot of the concerns you see? I know it's a bit of a loaded question, but thank you.
Thank you. Mr. Fox?
Thank you for your question. That's quite a broad, and I would agree, characterization loaded question, but I will go there. I think that, as an example, the Access Privacy Office has increased its staff by 2. We have been calling on that office to expand its cohort for a few years now. And it's certainly too soon to determine whether or not that's enough. Certainly, I think that's a really good faith effort or decision to do it. Now, I was told even 9 months ago that there wasn't any money for any new positions. But a few months later, that money was found somehow, and then it took a while to hire, and so we proceed on. I don't know if it's going to be enough. Time will tell. It will require those people to be trained and to get some real experience, and there is I think, another aspect to the whole project of access to information, which is, I would call it the bureaucratic enthusiasm for the whole thing. And some departments are, I would say, culturally more open than others. And some departments will be much more cooperative and disclose more easily than others. And I would characterize that as just an inherent sort of aspect of the situation, and probably a process of learning. As an example, I won't get into which department, but there is a new amendment to the Act that came into force in 2021 dealing with workplace assessment reports. HR issues typically are a fruitful place to look for access to information. A lot of people, if they're not happy with their HR system, will do access to information requests to get things. So workplace investigation reports are within a group of records that would be described in the Act, in this section 24.2, as information created or gathered for the purpose of a workplace investigation. And we have had a couple of files where there was a fundamental disagreement about what the Act requires in regard to these things. And part of the problem was that institutionally these things have been around for a long time, and they were held very closely. And the amendment was brought in, from what I can tell, to address certain issues about how those reports would be distributed or not distributed. And obviously those kind of things have very sensitive personal information in them, and they're, important documents, particularly for the people involved. We had some real difficulties or disagreements about what the Act actually required. But I think we're now at a point where the folks in human resources agree with us. So I don't think it was easy. I think it took maybe a bit longer to really grasp the nettle there for human resources to really figure out what this section requires or demands. But I have the sense that we're there. So I'd say growth is possible and change is possible. And this is a really good message, actually, because once those misunderstandings or different understandings are resolved, well, then we can get on with it and we don't have to keep revisiting the same issue.
Okay, thank you. Before we go to the second round, I do have a couple questions of my own. The first one I wanted to highlight is something that I emailed your office about earlier this year, and I wanted to ask it on the public record also and discuss it. There was a couple cases in the past year, or past couple of years, where there were incidents of deliberate snooping in health records, and your office made recommendations related to those, made recommendations. There was a certain amount of discipline that occurred, but the one thing that I think has been pointed out is missing, that could be put in place, is some kind of a firewall between staff who are uninvolved in a health file and that person's records. So effectively, there being an extra check saying, like, unless you are, you know, the physician or nurse or whatever who has been requested to kind of look at this person's files and deal with their health directly, you shouldn't just have open access to their files. I'm just wondering if you could comment on that, whether you think we should be putting even stricter controls in place that would help prevent these kinds of incidents. I acknowledge that they're rare, but the impact that they have on the people who they affect is enormous. And certainly I can think if my own record was breached in this way, the sense of violation would be enormous. And so I think it was clear to me in looking into these issues that that kind of, firewall may not be the right word, but that this kind of extra check would be a really good thing to have to prevent these kinds of incidents. I was wondering if you could discuss that. I don't know how this is handled in other jurisdictions. But I'm curious to hear your opinions on it.
Thank you, Mr. Chairman, for that question. And we could talk at some length about what's in that question. But the way the Act works is that no health information custodian or employee of is entitled to access a person's record unless they're delivering a health service or some other purpose, either related to a health service or a few others that are listed in the Act. So your question is really directed to people who access medical records, typically the electronic ones, without any legitimate authorization or reason to do so. So right now, that is clearly unlawful. And if it happens and is discovered, then the investigation, from what I've seen, is typically taken very seriously. Often people, you know, the two people I can think of offhand that I think you're referring to were put on suspension, albeit with pay, until the matter was resolved. I do think that there is a sort of a managerial issue within, say, NTHSA to know how exactly to deal with this, because one of the issues that arises very quickly if there's an allegation that an employee has been, you know, looking at someone else's personal health information without authorization, which I'll call snooping, that's a fireable offense. And it's definitely something to which discipline could, and if it happened, should result. And so that becomes an HR issue as well. And I think those things are then in two different sort of groups to investigate. There's a human resources aspect, there's a privacy aspect, and you know, who's leading, I think, can be a bit unclear. Now, your question, I think, is more geared to how do we prevent that from happening. And, you know, first and foremost, the way it's against the law, and you could lose your job if you do it. And that should be a pretty compelling reason, and I think it generally is. I mean, if people are aware, and people who are employed by the department or by one of the health authorities, they should know, and I think do know, that this stuff is unlawful and could result in loss of their jobs. So for most people, that's a pretty compelling reason to not do it. I don't think inadvertent access to records because someone says, oh, I didn't know I couldn't do that. I haven't run into that. I know that may have gone on a bit in one or two instances when the electronic medical record system was first created and people didn't really know what it could do and were maybe experimenting with it. But that's not an issue now. By making it unlawful, by making it a very serious offense for which you could receive discipline up to and including dismissal, and certainly there's one case not too long ago where someone snooped, relayed information to another person and lost their job as a result. That's the deterrent. Now, you raise another question or a possibility that, well, you could have another check in the system, if you will. Say, well, if this person is involved with the patient care, then and only then you can access the information. And I would say that, I mean, this discussion has gone on, but the idea of a quote, circle of care, where there are some individuals involved with the patient care and some and the rest are not, is not the way this electronic medical record system is set up. And because of the nature of delivery of health services, where nurses come on and off shift, clerks come on and off shift, doctors come on and off shift, there is often a need for people who didn't have initial involvement with a patient to then have more involvement with the patient. And the mode of control is through the deterrent effect of a directive not to be accessing that personal information unless you're delivering the health service. To try and impose further sort of gatekeeping by pre-identifying who is within and who is without a quote circle of care, that might be a way to do it, but this machine that they have, the electronic medical record system, as far as I know, is not capable of doing that. And I think there arguably are obstacles to doing that, because if you have to pre-authorize people, one could almost immediately see that you would start pre-authorizing anybody who might need to look at it. And you would sort of lose that exclusivity of access, which might be a way to limit the possibility of snooping. So I frankly think that it's entirely appropriate to trust those in the medical system to exercise their power to access personal health information responsibly. And I think almost most of the time that's the case. Once in a while, it isn't. Snooping events are rare, and but they are also quite alarming when they happen, because, as you know, Mr. Chairman, that sort of intrusion onto someone's personal information can feel quite violating. And I think that's one of the reasons why, very quickly suspension and or dismissal is in the sights in terms of an HR response, because it is so vital. Because if you can't trust the responsible handling of your information and protection of your privacy, then patients are going to be less likely to go to their healthcare providers. So, in terms of your proposition, I mean, that would ultimately be for NTHSA or the department in terms of whether or not they could accommodate such a thing. And I do know that they are currently still looking for a new electronic medical record system. I don't know one way or the other if any kind of ability such as you're suggesting would be on their list of features that they're looking for.
Okay, thank you. I really appreciate the comprehensive answer to that question, and I think it's given me some things to think about and certainly follow up on, because yeah, I think there has to be a balance struck between the administrative burden that we're placing on the system and the importance of protecting privacy, particularly with records this sensitive. And so I think that there is a balance to be struck. And certainly, I personally want to believe that it would be possible to, at the very least, limit the number of people who have access to people who are most likely to be involved in the person's care. And I think there's some basic things that could be put in place, if not, at the very least, something to simply prompt a healthcare practitioner to check a box saying, yes, I am directly involved in this person's care. And when they've checked that box, they've been reminded, if you aren't, you're breaking the law. And yeah, okay. I'll give you the chance to have a quick follow-up on that one. The next question I had was on a very similar thread that Ms. Reed and Mr. Rogers were already going down, but that is on just the overall administrative burden of the system. And I'll just say, I occasionally have the opportunity to chat with folks who work within the government. And, one of the questions that I've asked is, what is something that you would change, or what is something that is kind of getting in the way of you doing work? And I think that's a constant problem that MLAs are trying to balance is, we want to do a lot of things. We want to help people in a lot of different ways, and there are limited resources within the government. I was very surprised to hear from more than one person that ATIP is one of the things that eats up the vast majority of their time and gets in the way of them working on problems that are more directly related to helping people, services that the government is delivering in whatever field they're working in. I was very surprised by that. And it's really gotten me thinking about ATIP and how it works and the role it plays in the government. And I would say that I came into this role with an inherent value that, yes, the government should be transparent with all of its information. And I think we had this conversation last year in the sense that I was asking similar questions. And, the call that came from you was, well, the government should just make everything as transparent as possible to begin with, and that'll significantly reduce the amount of things that people have to ATIP about, and I agree with that. But I guess to just kind of build upon the questions that were already asked is, do we need to rethink the way ATIP is working, considering the administrative burden that it creates? And I guess the question I would ask, the answer seems to have been like, we need more resources, we need better records management resourcing and things like that. But the problem is that the truth that we are facing is that the government can only get so big. We only have so many resources to pay people. And we may simply not be able to afford, based on what people are willing to pay for government through their taxes, to resource the system at that level. And so how do we manage this problem? How do we balance the need for public access to information and the need for government to be efficient and effective and serve people? It's probably the biggest question you can be asked, right? So just putting it out there.
Thank you, Mr. Chairman, for such an easy question. Let me chip away at that a little bit. Should government be transparent? Yes. Does that take effort? Yes. Is that effort directly related to the responsibilities in line departments when they're trying to deal with all of the things that they're created to deal with, whether that's climate change or municipal services or running the court system or creating roads and bridges? No. Access to information is something that has been added on. In this jurisdiction, it was added on in a formal way in 1994. Federally, it was added on in 1981 or 2. Access to information is, in that sense, a somewhat new idea for bureaucracies. And, bureaucracies are pretty slow-moving things, as you observed earlier. Well, we have a lot of impatience, I think, in our lives because so much of our lives now respond within fractions of a second, and we just think that everything should move that way. And unfortunately, some of our structures and institutions were created when that wasn't the case. Indeed, as reviewed just a bit earlier in the presentation, when the Act came into force, I think there was actually email in 1994, but nobody used it much. I know when I was articling in 1993, you could not run WordPerfect and the email program at the same time. You'd have to log out of one to do the other. So things have changed. And the expectation of timely responses that's built into the Act is more and more challenging because we live in an era where records can proliferate really easily at the press of a button. You know, an email with a document that goes out to 5 people, and then those 5 people make comments and send it to 5 other people each. Suddenly you have 25 different versions of a document, all of which could be separately, you would be required to be separately obtained and disclosed. So in the old days, it would be done on paper, and there wouldn't be so many copies. And so we have a fundamental challenge there because of the proliferation of records that contain text. And it's a problem. Now, I know that the records management people who exist and have expertise that may not always be listened to would say that discipline around the creation and storage of documents is key to helping this whole process, ATIP included, work better. Also helps bureaucrats find things as well. But this takes discipline, and it's difficult, and not everybody sort of takes to it. But in as much as government has this interest in its own information, document management, records management is really key. And one of the benefits would be that responding to access to information requests might be easier if the document management systems that across government were perhaps more standardized and were more more standardized and complied with across the board. And my observation is that different departments have different approaches. They all are supposed to have the administrative records. How does that go? ARCs and orgs.
ARCs and orgs. And DIMS.
And the use of DIMS, being the electronic document management system, is not universal. Some departments are using it, some aren't. Everybody's using email. Some bureaucrats, I think, are still keeping documents on their laptops or on their phones or on their desktops, and those documents become unavailable to anybody else unless they've got the login to that particular machine, which is not a useful way for a government to store its information. It also presents real problems when you're trying to collect that information. So the solutions for government to try and deal with the administrative burden of responding to access to information requests, I think it starts a little bit upstream of the request. It starts with records management. It also starts, as you pointed out, with having a more open publication of records that might be of interest. For instance, government departments frequently will contract for consultants to do reports on any number of things. And those are matters typically of general concern. They may be simply fact-finding kind of reports. They're not often put out there. They're often the subject of access to information requests. And if they're dealing with personnel issues, that's a different thing. But if it's a feasibility study on a railroad track, or something of this nature, it's like, well, that could be interesting, but why would it not be, as a matter of fact, published on a website when it's received? And I don't really know the answer to that question, and it would probably be different depending on what the report is. But there doesn't seem to be a regular practice of putting that kind of information as a regular practice up on the web. When we get something new, let's put it out there. It doesn't quite happen that way. And so, you know, when there's a report filed, well, someone's going to do an access request to get it, which begs the question, why do you have to do that? Why doesn't it just go out there? It's public information. I'll just make one other comment, which is coming back to the idea that this government needs to be transparent. It is a public government. It's a democratic government. And there is absolutely a cost associated with keeping it that way. And yes, government should be efficient and should be using its resources as best it can. But that access piece has to be recognized as a separate and worthy goal in addition to those line items that from a policy point of view, departments are created. The Department of Education is created to do education work. You don't see Department of Education and ATIP, but it's there because people need to know what their schools are doing. All you can say really is that, yes, that's more work. And because it's the law, those public bodies need to put the resources necessary to comply with the law. And that's sort of as reductive and simple as it gets.
All right, thank you. Committee, we are quickly running out of time, but we do have time for everybody to ask one quick question if they have any left. So does anyone have any burning questions that have been left on the table? Okay, seeing none. Mr. Hawkins is okay? Okay. Excellent. Okay, I think the only thing I would ask is that you seem to have a further point on the health question that I asked. I don't know if I am able to jog your memory on that, but I just wanted to give you an opportunity to respond to that.
Thank you, Mr. Chair. Yeah, I just wanted to sort of expand a little bit on how the system works, because it is not the case that anybody with a sign-in to the electronic medical record can see everybody's information. There is a system called roles-based access control. So if you're a clerk working in the emergency department, you'll have a certain kind of access you can get. If you're a doctor working in orthopedics, you'll have a certain kind of access. Not everybody gets to see everything. Now, I think, and I won't really speak to like how that's divided up, but not every, so that is one control that they do have. So if you need access to do your job, that's what you get. You don't get to see everything. And I should point out that there is also an auditing function that the department does do. It's not capable, as I understand, of catching every single instance of snooping, but they do audit for unauthorized access, and where they find it, they do take action.
Okay. Excellent. That's good to hear, and I really appreciate the comprehensiveness of the answer. So, seeing no further questions from committee, I just wanted to, on behalf of committee, thank you for taking the time to present to us today, and echo my colleagues' comments that I really also appreciated the very dynamic presentation style. It was certainly grabbed my attention, so thank you for that. And I'll give you the opportunity, both of you, to share any closing remarks or final thoughts or anything that you felt we didn't cover today before we close off the meeting. Thanks.
I will just simply say thank you for the opportunity to be here and to answer your questions. I'm experiencing a little bit of envy because I've never had anyone actually say, what a dynamic performance.
I told you I was a good hire.
So I will say thank you to my administrative commissioner as well, or my assistant commissioner.
Okay, thank you. I mean, we all have our different skills that we bring to the table here, so it's good to have a mix, right? So thank you very much again on behalf of committee for appearing today. That brings this briefing to a close and concludes the public portion of the meeting. As always, colleagues, I would ask that you stay and stick around for the in-camera debrief. Thank you very much again to the Information and Privacy Commissioner's Office.